about these arguments, being Chinese American and minority in this great country of America?
Well, I'm certainly well acquainted with discrimination. I am a little bit older than you too, probably. I'm very sure I am. And I grew up here in the 60s. I came to the United States when I was 6 years old. I grew up in Pasadena. Mm-hmm. I was one of 2 families that were Asian Americans in my elementary school. I endured ridicule, discriminated, certainly. I totally understand about civil rights. I totally would have appreciated an organization if you had existed then. But of course, through the years, and there are organizations that have helped us, Asian Americans, to achieve our equal status. But gay marriage is not so much about equal rights, because what they're asking for here is to redefine the term of marriage. Now, right now, do gays have equal rights as heterosexual marriages? Yes, they do. Under the California family law, there is domestic partnership. If they register as a domestic partner, according to the code, they have absolutely same right as every other marriage. And so it's not so much about right now. As a minority, I am worried about my rights being protected, and gay rights are protected. Bill Clinton made sure that gay rights were protected, but he is not for gay marriage. Bill Clinton is for gay rights, but not for gay marriage. So it's not so much about their rights, but that the term marriage is something that needs to be protected as between a man and a woman. And that's the difference between that and interracial marriage. Interracial marriage affirms marriage between a man and a woman. And there's nothing in the Constitution that says that you have a right to marry whoever you want. There's no Constitution right about that. In fact, marriage has never been about marrying whoever you want. There are laws. You cannot marry your sister. I mean, Henry, you cannot marry your sister if you had a sister. You cannot marry your mother. You cannot marry somebody else's husband if they're already married, so that protects us against polygamy. So marriage itself, marrying whoever you want, is not a constitutional right. And if you're talking about gay domestic partnership rights, I am for domestic partnership rights. I believe if 2 people are in a partnership and they register with the registry, the law allows for them to have equal rights. And in fact, I was reading that in the San Diego Tribune, they were saying that if same-sex marriage might even damage the rights that were gained through domestic partnerships. And I understand the gays have been fighting for their rights, and I understand that. I'm sympathetic to that, like I said. And they have fought for their rights under domestic partnership. And if marriage becomes legal, they might even begin to lose those rights they had gained through domestic partners. People might say, well, now you can get married. Why do you need domestic partnership?
Right. Then, Kate, let's hold on to that thought. That's very interesting about the difference between domestic partnership and an actual marriage. Let's take a commercial break, and when we come back, let's explore that further. Okay? Welcome back to Community Roundtable. I first apologized. I think I called Kathy on the last segment. I apologize for that.
That's all right.
But following on our last segment, you were talking about domestic partnership and the definition of marriage. You're saying that actually if the proposition doesn't get passed, they were legal to marriage, that they actually might lose some benefits?
Well, that was something that I read that is possible to happen, because right now gay couples obtain their rights, equal right protection, which I totally agree with, under a domestic partnership.
Mm-hmm. Okay. Well, I guess we'll come back to Karin. I know also Carrie brought about a lot of issues. One of the things that I like to explore further is the domestic partnership. That, what's the difference between it, and what's your argument about that?
So I think Katie brought up an interesting point about what would happen to domestic partnerships if gay marriage is allowed to remain legal. And so I think that actually we have to take a step back from that. So one thing one thing I think it's important to look at the historical context of how we got to where we are today, and how California, in some ways, is different from many other states that have made decisions about this issue of gay or same-sex marriage. In California, we actually, because we are often ahead of the curve on everything, and as racial minorities, we often benefit from that. We are better about issues around language and immigration, citizenship, the kind of things that impact many Asian Americans directly. We have also been ahead of the curve on gay rights issues. So domestic partnerships was something that many gay rights organizations and activists and even civil rights groups supported because, in lieu of having marriage, if you don't have marriage, then, domestic partnership is certainly better than having nothing at all. But what I think is really interesting is if you look at the California Supreme Court case that came down in May, that was a case that it was the first time in the country when a Supreme Court, many Supreme Courts have ruled on this issue of whether gay marriages should be allowed to be legalized, whether they violate the state's constitution. So California was not the first state to rule. In fact, Massachusetts was the first state to rule. They allowed gay marriage first. But California was actually unique because at the time California ruled earlier this year, we were the first state where a Supreme Court had to look at a state where you actually had some other alternative for gay couples. And in our case, we had domestic partnerships, which was true. The goal was to get as many rights as possible for gay and lesbian couples to have rights because they couldn't actually get married. And that's why the lawsuits were also filed, because they were trying to get the right to marry. Ultimately, you want the same thing everybody else has. You don't necessarily want the second alternative, but sometimes the alternative is better than absolutely having no rights at all. So that's what domestic partnership did become. And the California Supreme Court spent pages and pages, it's like a 120-page opinion. They talked specifically about the fact that for the first time, the Supreme Court was being asked to look at the issue of when you have a state that has given rights under domestic partnership to gay couples, and you also have marriage, a legal right to marry, a civil legal right to marry, different from what churches or what people do as kind of the celebration, but the legal right. When you have those two things, do you still have inequality? And the court spent a great deal of time looking at this. I mean, that's why they have 120 pages. It's one of the longest opinions I've ever seen. And they said, their decision after much analysis was, it's not the same thing. And what, again, I said my background is as a civil rights lawyer, and what's interesting is the language they use is very similar to other cases where courts at the state and federal level have said, you cannot have two separate things and have them separated out and actually have them equal. There is no instance where separate has been considered equal. So, we've had segregated schools in the past. Actually, in the state of California, you had Asian kids that had to go to different schools because they couldn't go to the schools the white kids went to. And that was always found to be unequal and against the law. So separate has never been found equal by the courts. And that's what the courts ruled here in California, was that, in every other state, they actually don't have any other option for gay couples. So the issue was just marriage or nothing else. But California was presented with this idea that, wow, we actually have domestic partnership, and is that enough, or is there something special about marriage that makes this unequal? And the court actually said, marriage is about the rights and responsibilities, but there's also this intangible to it, which is that if one group of people has to call it domestic partnership, they're always singled out as being treated differently. They're always going to be second class in that way. Straight people don't want to have domestic partnerships. If they can, they want to get married. If you told people you can't be married anymore and now we're all going to be domestic partners, people would be like, well, wait a minute, what just happened? We want to be married. We don't want to be partners. And so the court was very clear about that. And I think what's interesting is California was the first, but just last month, or maybe it was earlier this month, the Connecticut Supreme Court ruled the same way. Connecticut is another state where the Supreme Court actually said gay marriages have to be allowed. In that case, it's because they had civil unions, which is a little bit different than domestic partnerships. And they said we are also a state where there is an option, an alternative for gay couples. And our role as a court is to look at it and say, under our state's constitution, as in California, they both said, under the Constitution, is having a separate system enough, or do we need to give everybody the same right? And both courts decided you have to give everyone who wants to be married, two consenting adults who want to be married, the right to be married. And so a domestic partnership and a civil union are not enough in those cases. And so I would say that that's probably the most important thing to remember, because it is you have to take into context what these other laws say and what has happened, whether a state has civil unions or domestic partnerships, and whether that's being compared to gay marriage versus gay marriage in a vacuum.